presenting the Fourth Amendment, and Mr. Bonner will be presenting the Eighth. The surveillance, arrest, and subsequent conviction of Mr. William Dunoff Jr. was in accordance with the Fourth Amendment for the following reasons. As a guest to the property, the defendant lacked sufficient standing to assert a Fourth Amendment claim of privacy. The property lacked heightened privacy protection. Also, use of a drone for aerial surveillance by law enforcement is permitted and is not considered a search. And finally, the exigent circumstance of protecting human life forced immediate intervention. This court has consistently held that in order for a person to claim a Fourth Amendment protection of privacy, they must have standing. The first component of standing, injury in fact, is defeated in this case because it is the property owner or the leaseholder who owns the protection at their location. Justice Kennedy, in his concurrence to the majority opinion in Minnesota v. Carter, referred to the Fourth Amendment protections as personal in nature and cannot bestow vicarious protection upon those who do not have a reasonable expectation of privacy in the place to be searched.
But it was in that case where the majority held that an overnight guest at a residence has a reasonable expectation of privacy. Is that correct?
An overnight guest, as we understand it in the record right now, Mr. Dunoff did not intend to be an overnight guest at this property.
Well, I thought it was in the record that he invited Jane Doe the day before to the RV and was found the subsequent morning at the RV.
He was found the subsequent morning. Okay, that part I did miss. So I'll have to claim loss on that. Okay. So moving forward. But considering that the defendant was not the property owner, he did not own as not the property owner, the defendant did not have the authority to claim the protection of privacy that the owner held. Now, referring to the Comerford Properties weakened expectations of privacy and also Plainview doctrine diminishing the defendant's further claims, first we have to take a look at how case law has consistently held that the home is always the place where your privacy protections are most scrutinized. In fact, the court has previously referred to the home as first among equals. However, in the particular case, what we're looking at is the Comerford property the Comerford property as described in the record is basically a heavily wooded area, not used as a residence. Rather, they have described it as a place where they have come for recreational purposes.
So it's almost like a vacation, or a place to get away from your regular home. That
would be the way that they have described it themselves in the record. That it was, in fact, they used the words getaway and to relax, if you will. I understand in the record it demonstrated that Mr. Comerford himself and his partner have spent the night there, but we haven't seen in the record, absent the current case, that Mr. Dunoff has ever spent the night there, as far as the investigation has been determined. But seeing as how the property has not been used as a primary residence, secondary residence, or in substitution of the primary residence as a regular occurrence, that fact applies the lower standard of protection to the property. Now, Plainview doctrine.
So if I understand your argument, so a vacation home or a second home doesn't receive the same Fourth Amendment protections as the primary home?
Forgive me, I misspeak there, because in any residence or location used as substitution for the primary residence does enjoy that primary protection under the Fourth Amendment. Any secondary property that wasn't being substituted would not.
I see. So this is more of a vacant. So if I'm understanding your argument, this is more of a vacant land and not so much a residence. So because of that, it should receive lower protections.
Well, the vacant land does apply here because we do know that it was vacant up until a few years ago. The RV was, there was a clearing made and the RV was posted there. But to the best of the record, we've seen that there hasn't been any significant activity that would demonstrate that it's been used as a substitution to the primary residence. So the vacancy of it, per its use at this point in time, as we've seen it by the defendant and his stepfather, that it really is just vacant land that they come to enjoy in the woods. separated by some 20 miles or so from their primary residence. It's outside the city limits.
Please continue.
So since Plainview Doctrine obviates privacy within a primary residence and its curtilage, as noted in Katz and Cirolo, it must do the same at a secondary property. The defendant was observed through an uncovered window of an RV on the Comerford property attacking another person. Because he made no subjective demonstration to shield his activity, he essentially surrendered his privacy in that case.
So wasn't it the case that there was a wood line surrounding the property closest to the roadway that obscured vision from the roadway?
Well, that would be from the roadway. Again, the present case, we're dealing with the drone that was observing from public airspace.
So it was obscured from the roadway, but not from a drone in the air?
Correct.
Okay. Okay, please continue.
Thank you. So because the defendant did not shield all of his activity from public view, which in this particular case it would be the public airspace, he surrendered his privacy in that moment. Now, next we'll consider the drone itself, as you brought that up, Chief Justice. The drone, the court has held in the past, and in fact, in particular, we can refer to the Michigan Supreme Court case of Long Lake Township v. Maxson, whereupon they cite Dow Chemical v. United States' interpretation of as visual surveillance as not being a search. With that said, we can also refer to Cirolo and Jardins, the rulings there noting that aerial observation is legal within public airspace, as long as it's legal from public airspace.
Well, wasn't it the case of Cirolo that there was no reasonable expectation of privacy to naked eye observations, not 10 times zoom observations?
Indeed, they did not argue actually in Cirolo over the pictures taken, because it was in the record, as a matter of fact, in the notes, that there were both pictures taken and there was naked eye observations. So the court hasn't actually made definition upon whether or not specifically whether or not having a photographic representation of someone's curtilage is incorrect. And so at this point, we can only take what the court has not used as being tacitly okay, because it was not brought into the court's purview at that time.
I see. So because it wasn't decided, it's still an issue that needs to be decided.
Well, I guess we can decide it here, but I would still argue that it's still perfectly okay to do so, as it's been done before, as well as in Jardins. Now, since aerial observation, since Cirolo and Jardins noted that aerial observation is okay, well, as long as it's done from public airspace, we next want to go ahead and consider what was the device that was used here, which in this particular case was a drone. Previously, the cases cited were a plane and a helicopter. But because we're dealing with the drone here, nothing changes about the aspects or prospects of this particular case. In fact, it's the drone itself, even though it stayed within regulation of the FAA regulations, flying at 375 feet above ground level, and didn't trespass upon the Comerford property line, nonetheless, all that was done was basic surveillance at that location, so no rights were violated in that instance. All right, finally, what we have here is just the exigent circumstance of protecting human life. Now, that is law enforcement's highest mandate per public, and the court, of course, recognizes this itself when it speaks in Katz about the negation of the warrant requirement under exigent circumstances. Here, the defendant was observed attacked.
Wasn't it exigent circumstances in the sense of evidence of a crime being rapidly transported from one location to another through the use of a vehicle, and not so much the actual crime itself?
Well, actually, I'm speaking to specifically the crime itself, that exigent circumstances. If there is a crime in commission, are the police required to seek and obtain a warrant in order to stop the crime from occurring? That would endanger the lives of others and possibly police as well. Seems to defeat the general purpose of what the police would actually need, what the police are designed to do.
If you'd like to briefly conclude, you will do so.
Bear with me. So in conclusion, really the main thing that we keep in mind here is that the state of Olympus investigators were under under the direct watch of the Attorney General's office investigating a crime, investigating the commission of crime, and we're still operating under the auspices of a proper investigation, utilizing tools that were already deemed by the court as being acceptable tools, observed a crime in commission, and acted immediately in order to protect human life.
Thank you, Counsel.
Thank you.
Your Honor, I am Attorney G.W. Bonner, and I will be discussing the Eighth Amendment issues, if it so pleases the court. It was brought up by our opposing counsel that the Constitution does in fact prohibit cruel and unusual punishment, but when verifying if a prison sentence is cruel and unusual punishment, the United States Court looks to Justice Anthony Kennedy's three factors proportionality, which was brought up by our opposing counsel. When using Justice Anthony Kennedy's suggested rules, the court looked at three factors in determining proportionality. The first was the gravity of William Denotes Jr.'s offense, which was a serious attempt of murder, and it was clear evidence that he was a career criminal as well. So we used his history to prove that case.
When you say career criminal, what do you mean by that?
In his younger years, he was in good problems with the law as well. He was causing destruction, even in the boot camps and stuff like that. The second issue in viewing present sentence, the second in viewing Justice Kennedy's rules was to see if the same prison sentence was issued in the same jurisdiction as well. The third was viewing prison sentences for the same crime in other jurisdictions. So we determined whether sentences were issued in the state of Olympus, and we also determined whether similar sentences were distinguished in nationwide. On its face, William Denotes' prison sentence is not ostensibly disproportionate. According to nationwide statistics, juveniles who attempted or committed murder in the second degree, about 50% received a prison sentence with parole after a minimum numbers of years served. Across the 51 states and the District of Columbia, the usual sentence, the range of years issued to be served in prison for the crime of second-degree murder was 25 to 50 years, which represents about 20% of all the inmates. William Denotes Jr. was issued the same sentence that 49 other juveniles in Olympus had been issued. Due to the fact that 49 others had received this same prison sentence, this makes this a usual occurrence, in essence not to be considered a violation of the unusual part of the cruel and unusual punishment of the United States Constitution.
I want to go back to something earlier that you said, because it just occurred to me right now. You said that this is a suggested three-part test, is that right?
I did not say subjective.
Okay, perhaps I misheard you, please.
Oh, correction. Yes, I did say suggested rules. I'm hanging myself there.
So then why is it suggested? I'm confused about that, because didn't the court, in an opinion, establish?
In Harlan versus Michigan, yes, they did suggest to use Justice Kennedy's three-pronged test.
Okay. I believe that was a misconcurring opinion, which is not the majority, I understand that. So are you taking the position that the court shouldn't follow that test here, or that it satisfies the test?
It does satisfy.
I see, okay.
Compared to other prison sentences issued in the state of Olympus to adults who were guilty of murder or attempted murder to any degree, where instead adults tend to be exact, had been executed or served life without the chance of parole. So had William Deneau Jr. been an adult, he would have received a much worse sentence than he did as a juvenile. Compared to nationwide statistics, William Deneau Jr. was issued a prison sentence that usually happens half the time. William Deneau Jr. is issued a tantamount prison sentence to the 30,580 nationwide inmates prior to his incident. Based off of this information, this makes his prison sentence to be a usual occurrence, in essence not to be considered a violation of the unusual part of the cruel and unusual punishment clause of the United States Constitution. Your Honor, it is my belief that the state of Olympus bestowed the correct prison sentence procedures in following Proposition 417. The state of Olympus Penal Code Proposition 417 is a sentence determining procedure that had been adopted by the voters of Olympus as of 2018. Due to the fact that these procedures has been adopted and approved as the standards by the voters, again, William Deneau prison sentence does not constitute an unfair practice case for cruel and unusual punishment. If it was considered cruel and unusual, the voters of Olympus would not have adopted Proposition 417.
Well, I mean, voters have adopted laws that have later been struck down. Just
Correct.
simply because it's approved by a majority population doesn't mean that it's constitutional.
Correct. As of 2018, we are following.
I understand that Proposition 417 is still good law, it's still valid law until it's been struck down.
Yes, correct. And maybe that's what we're here to argue. When denying the claim of cruel and unusual punishment, we must refer to Jones versus Mississippi. In Jones versus Mississippi, the court held that in a case involving an individual who was 15 years old when he murdered his grandfather, the court held that a state's discretionary sentencing system is both constitutionally necessary and constitutionally sufficient. Also, we must take note that Proposition 417's prison life sentence are not considered to be mandatory. The life prison sentence declared in Proposition 417 are not mandatory prison sentences due to the fact that it allows for a requirement for juvenile offenders to initially be found corrigible. In other words, unable to be corrected. Here, William Deneau Jr. was found to be guilty enough to be sentenced to life with a chance to achieve parole. But taking into account his multiple negative run-ins with the law, William Deneau Jr. was in fact considered incorrigible.
Wasn't it the case in Jones versus Mississippi that the court held that at minimum, really the only thing the trial court must do is just be able to consider the age of the offender?
Here in the case of Deneau, there were many similarities though, but many differences is that they were offered the possibility of parole. So compared to Jones, Deneau received a better prison sentence due to his achieving of possibility of parole. Got it backwards. They were not offered the possibility of parole.
I see. So in that case, it was a life without parole sentence.
And in this case, he did achieve parole.
But wasn't it the court in Jones, I thought, held that the only thing that's required is that the scheme must allow for a judge to consider the age of the offender, and that's about it. Was that met here?
Yes, they looked at his prior histories.
Okay.
They, like I mentioned about him being incorrigible or not, they did look at that. And since he had been a previous felon, not felon, he had run-ins with the laws, they looked at that to consider his life sentence. I have two conclusions, one for myself and then one for both of us. In closing, William Deneau Jr.'s prison sentence was not cruel and unusual punishment due to the fact that his prison sentence is one, not ostensibly disproportionate, two, his prison sentence is indistinguishable to other prison sentences in the state of Olympus, and three, his prison sentence is undistinguishable to other prison sentences and other jurisdictions nationwide. All of which points to Justice Anthony Kennedy's three factors in determining proportionality. Also, the state of Olympus has in fact bestowed the correct prison sentencing procedures in following their own penal code Proposition 417. and in doing so, they have denied the claim of cruel and unusual punishment by following precedents set by Jones versus Mississippi. To wrap up both of our arguments, in conclusion, the state of Olympus did not violate petitioner's 4th and 8th Amendment rights. He lacked standing to claim a reasonable expectation of privacy, and the aerial observation by the drone did not constitute a search. Additionally, petitioner's prison sentence aligns with proportionate criminal conviction sentence as prescribed by the 8th Amendment. As a result, the court should affirm petitioner's conviction and